Good day, ma'am. Today I am going to report the chapter 2 of the subject Legal Aspects in Tourism and Hospitality. Here are the learning objectives. First, identify important provisions in the Philippine Constitution related to tourism and travel. And second is to enumerate the rights of travelers as well as entities engaged in the entire tourism, travel, and hospitality industry. The Philippine Constitution. It is the right of every Filipino to travel. Traveling is one of the most enriching experiences in life. It allows one to discover new places, interesting people, and novel ideas. The Constitution is defined as the original and fundamental principles of law by which a system of government is created and according to which a country is governed. It is the fundamental law of the land to which all other law must conform. It is a written instrument by which the fundamental powers of the government are established, limited, and defined, and by which those powers are distributed among several departments for their safe and useful exercise for the benefits of the body politic. Next is Article 3 or the Bill of Rights and Article 12, which is the national economy and patrimony, are some of the constitutional provisions related to tourism which may be given preferential attention. And here we have the Bill of Rights. Section 1. No person shall be deprived of life, liberty, and property without due process of law, nor shall any person be denied the equal protection of the laws. This excerpt emphasizing the protection of individuals' fundamental rights. It prohibits depriving anyone of life, liberty, or property without fair legal procedures and ensures equal protection under the law for all. The essential requirement of procedural due process in the court are as follows. There must be a court or tribunal clause with judicial power to hear and determine the matter before it. Second, jurisdiction must be lawfully acquired over the person of the defendant or over the property which is the subject of the proceedings. And third, the defendant must be given an opportunity to be heard. And last, judgment must be rendered upon lawful hearing. Next, in many instances, communication and correspondences are inevitable in tourism, travel, and hospitality industry. Because of its daily use, it is important to understand what law may be applied. In section number 3, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Section 3, number 2, any evidence obtained in violation of this or the preceding section shall be inadmissible for any purposes in any proceeding. This passage appears to be a legal provision emphasizing the inviolability of privacy in communication and correspondence within the context of tourism, travel, and hospitality industry. It specifies that such privacy can only be breached with a lawful court order or when necessary for public safety or order as defined by law. Additionally, any evidence obtained in violation of these privacy protections is deemed inadmissible in legal proceedings. Next, for a labor-intensive industry like the tourism, travel, and hospitality industry, it is common to have disputes between the labor sector and management. Likewise, depiction of women and children in an exploitative manner has happened in the past. Freedom of, freedom of speech has to be understood in the right context. In the section 4, it is stated that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. In the tourism, travel, and hospitality industry, labor disputes and concerns about exploitative depictions of women and children can arise. The quoted Section 4 of the First Amendment protects freedom of speech, expression, and the press, as well as the right to peaceful assembly and petition for grievances. While these freedoms are vital, understanding the responsible context is crucial in addressing industry challenges and ensuring fair treatment. Next is every person has the right to travel and reside anywhere he chooses. In section 6, it is stated there that the liberty of abode and changing of same and the changing the same with the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by the law. This passage, likely from a legal document, asserts the right of individuals to choose their residence and travel freely. It specifies that this liberty is subject to limitations defined by law, with court orders required for any restrictions on changing residence. The right to travel can be restricted only in the interest of national security, public safety, or public health as outlined by relevant laws. Next, once again, the labor-intensive nature of the tourism and travel and hospitality industry elicits the possibility of unions and associations being formed to protect the rights of employees. While there is a provision in the Constitution on this matter, a lengthier discussion is covered by the chapter on the labor law. Section 8, it is stated there that the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. The law mentioned appears to highlight the constitutional provisions regarding the right of individuals, both in public and private sectors, to form unions, associations, or societies for purposes that align with the law. This protection ensures that employees in labor-intensive industries such as tourism and hospitality have the freedom to organize for the safeguarding of their rights. Then let's proceed. The tourism, travel, and hospitality industry makes use of a lot of contracts. For example, employment, engagements, agencies, sales, franchise, property management, purchase, services, and the like. Thus, it is important to study obligations and contracts. It is stated there in section 10, no law impairing the obligations of contracts shall be passed. Section 10 emphasizes the legal principle that no law should be enacted that undermines or impairs the obligations of contracts. This provision underscores the importance of respecting and upholding agreements, including those commonly used in the tourism, travel, and hospitality industry, such as employment contracts, engagement agreements, agency contracts, sales contracts, franchise agreements, property management contracts, purchase agreements, service contracts, and similar arrangements. Then we have many multinational corporations want to invest in the Philippine tourism, travel, and hospitality industry. It is important to study to what extent and how they can invest. In Section 11, no franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines or at least 60% from of whose capital is owned by such citizens, nor shall such franchise, certificate, or authorization be exclusive in character or for a longer period than 50 years. Neither shall any such franchise or right be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. The state shall encourage equity participation in public utilities by the general public. The participation of foreign investors in the governing body of any public utility enterprise shall be limited to their proportionate share in its capital, and all the executive and managing officers of such corporation or association must be citizens of the Philippines. Section 11 outlines the regulations governing the grant of franchises or authorizations for operating public utilities in the Philippines. It specifies that such privileges should generally be given to Filipino citizens as public equity participation in public utilities and restricts the involvement of foreign investors in the governing body, ensuring that executive and managing officers must be Filipino citizens. Next, the country takes pride in developing a skilled workforce ranging from blue-collar to white-collar jobs, from managerial to entrepreneurial talents, from scientists to artists. There is a provision in the law that limits the practice of professions. This may shortly change because of the reciprocity, especially when certain agreements in the World Trade Organization covering movement of people and services will be implemented globally. In Section 14, the sustained development of a reservoir of national talents consisting of Filipino scientists, entrepreneurs, professionals, managers, high-level technical manpower, and skilled workers, and craftsmen in all fields shall be promoted by the state. The state shall encourage appropriate technology and regulate its transfer for the national benefit. Section 14 underscores the state's commitment to nurturing a diverse and skilled workforce, encompassing scientists, entrepreneurs, professionals, managers, technical manpower, and skilled workers. The provision highlights the promotion of sustained developments in these fields, emphasizing the importance of Filipino talents. Additionally, the state is mandated to encourage appropriate technology and regulate its transfer for the benefit of the nation. This commitment may undergo changes due to international agreements, especially within the World Trade Organization, which could influence the practice of professions and global movement of people and services. And that's all for the chapter 2. Thank you for listening. I hope you learned something. Bye.